Where's your clicker? Of course, that's up and down. Hi, good afternoon. Thank you very much. I can't stand in front of that thing. Thank you very much for showing up. My name is Bill Klingberg. Expertise. We have lawyers, we have accountants, we have sales and marketing people. Does everybody here have a mentor? If you don't, and you would like one, you can go to our website, houston.score.org. And on there, near the top, there's a tab called Find a Mentor. There's two ways you can do that. You can put down, type in a description of your question and let us find you a mentor. Then that person will communicate with you via email and set up a mutually agreeable meeting time. Excuse me. The second way is to put in a keyword. Let's say you want to start a restaurant. Obviously, you would put in restaurant. And that would pull up people with your that experience in your marketplace. Obviously, excuse me. Obviously, that helps to have experience in a specific marketplace. So those are the two ways. If you want me to show you a little bit after the presentation, I'd be happy to go through some of that. Or you can grab my card and you can email me and I'll try and set you up with the right person. Okay? But the whole thing really works better if you have a mentor. We have 135 members here in Houston. Not one of us knows everything. And the key behind it is to have a mentor who can kind of be the focal point and bring in expertise when and if it's needed. And bring in expertise when and if it's needed. If that mentor doesn't have it. Any questions right now? Okay, great. We'll get started.
Okay.
Rita Leader.
My name is Rita Leader. My background is in corporate law. There are several attorneys within SCORE. We have to emphasize that SCORE attorneys can't represent your business or in litigation, but we do give general business guidance. So that is the purpose of my presentation today. Give you some guidance on the typical legal issues that arise with small businesses. Now, this could be a very broad topic. Any attorney would be sort of amazed and overwhelmed by the notion of finding out what legal issues are most important to small businesses. I will tell you, yes, sir.
There's a mic. We're trying to capture the live stream.
Oh,
So we need to make sure we give you a mic.
okay. I've got one mic. This is not the right one.
You do have a mic? Oh, wait.
But it's not plugged in.
Yeah.
Quincy said something about he was still.
So continue on. We'll figure this out, trying to be seamless as possible.
Good, thanks. So we give general guidance, and I'm going to cover some legal issues that in my 8 years of counseling with scores of small businesses I've seen are most important to them. This is what I've got a background for. So this is what we're going to cover today. Choice of business entities is the biggest one if you're considering starting a small business, or maybe you've got one started and are interested in going into a different entity. I'm going to give you background on those. Touch lightly on regulations, because regulations are huge and can be at a lot of different levels. Insurance and taxation for the various entities. Finally, a little bit of intellectual property advice regarding a company name choice, trademark, patent, and copyright protection. So let's start off with the business organization. These are the principal forms of business organizations that we see small businesses. A sole proprietorship, which is just you, no entity, you just go out there and do business. I have a lot of clients from different cultures who come to me and say, help me get a business license. Well, no such thing. You want to do business, you just go out there and do it. There are certain requirements, and we'll get to on the sole proprietorship, but this is basically you. Because a sole proprietorship is one person, we have the option of more than one, which is a partnership. This is a general partnership. Finally, a limited liability company. There are two kinds of LLCs that I'll go over today. One is a standard form of LLC. The second is a series LLC. Corporation. Now, a corporation is a single entity when you set it up with the Secretary of State's office, but it can be taxed in one of two different ways, either as a C corporation or an S corporation. And finally, we have just recently from our state legislature a new form of corporation called a B corporation, which is a public benefit corporation. I'm going to focus on that as well. So my approach to this is to show you advantages and disadvantages of each form. Have in mind your business, how does it fit, where are the pros and cons of going through this. So, as I mentioned, sole proprietorship, simple and easy to start. You just go out there and start doing business. Now, the public needs to be protected to know who you are, where you are. So there is a requirement if you're operating as a sole proprietorship to file an assumed name certificate in the county clerk's office of the county where your principal executive office is located. So that is like an $18 filing fee. You would simply file the assumed name certificate saying that you personally are doing business as Houston's best piano tuner. If I decide to do business tuning pianos in my own name, I don't need to file it. If I go up to Conroe and decide Houston's best piano tuner doesn't sell well there, I can sell myself as Conroe's best piano tuner and simply file an assumed name certificate in the same manner but in the Montgomery County Courthouse. This is good for 10 years. Know that you have no exclusivity with that name, which is to say there can be dozens of Houston's best piano tuners. You just file it as a matter of notice to the world. If people have done business with you and want to do business with you again, make good on a warranty, sue you, whatever, that's where they find you. And that is principal legal obligation if you're a sole proprietorship. There are low startup expenses because this is basically your own business. All the income is yours. Guess what? All the losses are yours too. Profits are not shared with anyone. You get to own, run, manage your own business. From a taxation standpoint, you simply put on your individual Form 1040 tax return as Schedule C the income and expenses of your business. And all the business expenses can go on that Schedule C in determining what the taxable income is. And then taxable income goes directly on your Form 1040. And finally, a sole proprietorship is not subject to the Texas franchise tax. This is not a tax on McDonald's franchises. It is the corporate income tax. And when we get to this topic, I'll explain more exactly what it is. Just know that if you set up a sole proprietorship, you will not be subject to that tax. So let's look at the disadvantages. Yes, you are the owner, manager, chief executive officer, but guess what? You're also the janitor, the supply clerk, the inventory person. You have to have diverse talents in order to do everything. Doesn't mean you can't hire someone to do your accounting, be a salesperson on commission, something like that. But you, as the owner, are going to be running it. You need to have diverse talents. Startup capital is based on your personal assets, so you don't have a lot of operating history by the company in earnings to take to a bank and say, here, loan money to this company, this business. And most importantly is the unlimited owner liability, which means that if there is a loss, a liability that arises in the operation of your business, someone suing you can get through to your personal assets. Your personal assets are at risk in sole proprietorship. Now, I'll tell you the state of Texas does protect the personal assets of its citizens to a certain extent. A judgment creditor, which is what someone would be if they had a claim against your business, can't get to your home, up to $30,000, $60,000 if you're married, worth of exempt property, which is basically your car, your furniture, your clothes, that sort of thing, adds up to $60,000 real quickly. And the tools of your trade, because obviously the state of Texas wants its citizens to go out there and work and make money so they're not on the public dole. So there are limits on what kind of liability you are subjected to, but I'll show you there's a way to protect this. And finally, the business may be dissolved when the owner dies. We see this so often. The sole proprietor is the one out there meeting the clients. He's the fresh face of the company. And when the owner dies, there's nothing left there. Whereas if there were a corporation or an LLC, there's something to pass on. So let's look at next at partnership. It's very similar to sole proprietorship, except it's more than one owner. The good news is then you've got somebody to share management with. That need for diversified talents, you've got it. You should always go into a partnership with someone who's got strengths different than yours, never the same ones. Or, as pointed out here, you can choose a partner who brings in capital. That's their strength, is they've got money. Your rich Uncle Harry says, sure, I'm interested in having you start this business. I will fund you with $100,000 and I want 50% of the company. Now, from a tax standpoint, the income is taxed at the partner level. If you've got more than one owner, you and Uncle Harry, you will file a report. It's not an income tax return, but a partnership report on Form 1065 that basically says the partnership made $100, it had $20 in expenses, and because it is owned 50-50, then $40 goes to each. There's something called a Schedule K1 that is provided to each of the owners to show the amount of income from the partnership allocable to them. That amount goes on your individual tax return. And the partnership also is not subject to the Texas franchise tax so long as all the partners are individuals. I'm sure you've seen the trend here. The Texas franchise tax applies to LLCs and corporations. So if one of the partners in your partnership is an LLC or corporation, they will be taxed on the partnership income, but individuals are not. Disadvantages of a partnership. I don't consider the first one to be a disadvantage because it's a matter of putting down in writing what your agreement is with your partner. You should have an extensive partnership agreement that basically says what each party will handle, the extent to which they have authority over expenditures, when your second signature is needed on a bank account, what happens in certain events when one is not available, that sort of thing. There is not a good template for a partnership agreement because it really varies with the partners involved. But we do have in our business library on the SCORE website something called a checklist for co-owners. And it's a kind of questions that you would go through if you are sharing ownership of any entity with someone to determine what should be responded to in a partnership agreement. Finding a suitable partner, very important. Having a business partner, is like choosing a spouse. You don't do it lightly because this is someone that you're going to be working with on a daily basis. If you initially come in and say you're 50-50 owners, you expect them to pull their weight, right? I'll tell you an experience I had with a woman who was a chef and a friend of hers, a man who was an architect. They had an idea for a new restaurant. So they went in, he was going to do all the design, the construction, everything. She had the recipes. So they were probably 50-50 going in initially because their efforts were somewhat the same, but when he finished with the design, she was carrying on running this restaurant. He had no further role in it. He'd like to believe that the success of the restaurant was due to his great design, so he negotiated and wanted to always have a percentage ownership interest in that partnership. But they negotiated it down to 70-30, which was more representative of their relative contributions. So they are an example of two partners who recognize each other's contributions, not always equal and interesting, easy to do. There could be disagreements over authority that should be covered in your partnership agreement. What happens when you're not both interested in going the same way, doing the same thing? Do you have a tie-breaking vote? Do you split up? It could be the end of the business. The profits are shared between the partners. The income allocation I was telling you about is an allocation of profit or loss. But this last item here that's most important is unlimited liability for each partner individually. So say I'm rich Uncle Harry and it was my nephew who went down to the Mercedes dealership and bought a new Mercedes on the partnership name, and then he ran off with it and never heard from him again. If he signed in the name of the partnership, even though I'm only a 50% owner, am responsible for 100% of that debt that was incurred. And I'll tell you, it's the same in your marriage. A single spouse may incur debt, but the community, both spouses are responsible for it. So that is something that should make you think, even though you're going into business with your best friend from high school, you know how people as they grow in age can go different directions. Maybe they're not as reliable. Maybe someone is convinced to run off to Mexico with a new Mercedes that they didn't pay for. As Uncle Harry would, of course, have a cause of action against my nephew to get back from him the 50% of the debt that he was responsible for. But that's the whole idea. He's a deadbeat. He's off with his Mercedes and girlfriend somewhere else and can't be found. So be very careful in a partnership arrangement because of this unlimited liability for each partner. So I'll get to the type of entity that is most popular with small businesses, which is the LLC, Limited Liability Company. It's been around 25 or 30 years now and is more popular than corporations, particularly for small businesses. The advantage is it is not difficult or expensive to form. It is a Form 205 that you file with the Secretary of State's office. The file is obtainable online, and you can even file it online and get a response within 48 hours. There are some provisions of it that are quasi-legal, and I'll be happy to talk to you about them. We have several attorneys within SCORE who can guide you through that Form 205. It's a $300 filing fee to the Secretary of State to file it. Any veterans prove their veteran status, and they have a waiver of that filing fee. So there is limited liability protection for owners. That's the name of it. Basically, you as the owner can protect your personal assets from liability for risks that arise in the operation of the business. Fewer rules and restrictions is really the reason why LLCs are preferred over corporations. The LLCs are not required to maintain the same records. They don't have to have an annual meeting of shareholders, an annual meeting of directors. Within a shareholder, some of you might own stock in a corporation, say in Apple. You know, as a shareholder, you'll be asked once a year to vote on the directors of Apple. So then the directors meet and they establish the policy for a corporation. And then they also elect the officers. Officers do the day-to-day management of a corporation. Well, in an LLC, all that is compressed into one person. You own it, you run it, you manage it. Generally are considered to be the owner as the member, and members can be the managers. There's no additional levels. So there's a lot of documentation and record keeping that is cut out. From a taxation standpoint, an LLC is a flow-through entity. You may have heard that referred to when the 2018 Tax Act was passed. The LLC itself is not taxed. The income flows through to its owners. There's only one owner. You simply report it on your Schedule C of your Form 1040 tax return. If there's more than one owner, you file that partnership tax return that I explained back under partnership, just because it's not a partnership, it's an LLC, but it's taxed as a partnership. So once again, you show the income for the LLC, less its expenses, and the taxable income is divided between or among the owners of the LLC. And another benefit of an LLC is that it can choose several forms of taxation. I mentioned if you're sole owner, it's your individual tax return. If there's more than one owner, you'll be taxed as a partnership. That's the default position. But you can choose to be taxed as an S corporation or as a C corporation. I'll explain what those taxations are when we get to those entities. Disadvantages. Once again, that you have to have an operating agreement, also called a company agreement. It's not, in my mind, a disadvantage. It's something that should help you. Basically, what it says is who the owners are and in what percentage. what their capital contribution is to the company. If you want to divide up responsibilities, one for sales, one for administration, you can do that in an operating agreement. How the profits and losses are allocated for tax purposes, which can be but do not need to be in accordance with the percentage ownership, and how cash is distributed, because that's a decision that you can make on your own. When do you actually distribute out cash? When do you take down a draw to cover your income? Because you don't really have a salary in an LLC. You just are taxed on whatever the taxable income is at the bottom of the year. So you just obviously need to take out money to pay your bills. That's the kind of draw that you have throughout the year. You do have to file and get current with the Secretary of State and Comptroller. And I mentioned the Form 205 that you use to initially file your certificate of formation. When you file this with the Secretary of State will send back to you, sometimes within 48 hours, or if you send it in writing within 10 days or 2 weeks, a certificate of filing, a certificate of formation. You hold on to that because you want to show it to your bank to open a bank account. You also need to get an EIN, as an employer identification number, from the IRS.gov, and you just basically tell them what type of entity you are. The other filings with the Secretary of State and the Comptroller are that once a year, on February 15, after you've been in business a year and 90 days, the Comptroller will send to you at the address you indicated as your registered office address in your Form 205, a franchise tax form. And you basically ask what your revenues were to see if you're subject to the franchise tax. And if you are, you can go online, indicate that you weren't subject to it, or you were, but you do need to respond, or there's a $50 penalty for failing to file. If you go for too many years failing to file that return, the Comptroller will decide that you really made a lot of money and you owe them $1,000 a year, and they will assess you that. Doesn't mean you owe it, it just means you haven't responded and they're suspicious. If you go for too many years without responding, the Secretary of State can revoke your right to do business in the state, which means all the benefits of limiting liability in an LLC are revoked. You're back to being a sole proprietor and unlimited personal liability. So very important to keep up with that annual filing with the Comptroller's office. The other thing that they will ask for that once a year is, it's called a PIR, Public Information Report. You will put on your initial filing with the Secretary of State's office who the managers of the LLC or directors of the corporation are. And if that changes, this is the time, once a year, when you need to tell the Comptroller that, basically, new manager or totally changed managers, and you make revisions to that PIR. The whole purpose of the PIR is to make sure if someone wants to sue you, the Secretary of State knows where to find you, knows who to sue. So that's how they do it, is through that PIR. There's no charge for filing it. There is a charge if you don't file it. So that's what it means to be current with the Secretary of State and the Comptroller. I want to make sure it's clear that $300 filing fee is only paid once and forever after. You just file your franchise tax report. There's no additional cost so long as you're not subject to franchise tax. Is there a question here? You file it along with the franchise tax report, and they're due May 15th of every year. Yeah, and it is annually. Yes, sir.
How much is the franchise tax?
I have a whole slide on that because it's not a simple answer to that question.
It's not a percentage.
It is a percentage of things, but there's a threshold amount. I'll tell you in advance so you won't get too concerned about it. You have to show that your revenues are over $1,130,000 in a year in order to be subject to the franchise tax. Now, I hope all you guys are there, at least next year. But if you're not, then you can check a box. What I urge you not to do is get that letter and say, $1,130,000, I wish, and toss it out. $1,130,000. And I should tell you, when this law was originally passed, the threshold amount was $1 million, and then there's a CPI increase every year for inflation. Every 2 years they change it. So that $1,130,000 is good for this year and next. The Texas legislature deals with the Texas franchise tax every year. There are bills introduced to get rid of it, to increase that threshold amount. You'll see when I get to explaining it's a really screwy tax, but the Texas legislature is always looking for sources of funds, so it's not likely they're going to do away with the tax. I will just tell you, it's meant for the Exxon Mobils of the world doing business in Texas. It's not meant for small businesses. And Texas as a state is really pretty generous towards and supportive of small business. I think it will continue to, that threshold will continue to increase, so fewer small businesses are subject to that tax.
If you change ownership throughout the year, do you file that change in ownership right away, or should you wait till you have to?
I'm glad you asked that because
Yeah,
no, the state doesn't keep track of your ownership at all. BIN really is just who they notify if someone wants to sue you. So if your ownership changed from the ones that you indicated on your certificate of formation, is you do not have an obligation to tell them at all. It's just if the person you named is no longer the one in charge, that's when you tell them.
and you change it according to your operating agreement?
The operating agreement can take care of who's the managing manager. You can do it in other documents, but yes, that's a good source for it, quite honestly, is the operating agreement. Okay, another disadvantage is that you should have a written agreement restricting the ownership transfers if you have more than one member. This is in the event that you have, say, 2 members and one of them dies, becomes disabled, has a divorce, and the family law judge gives the ownership of his LLC to the ex-spouse. Bankruptcy can also control. There's certain events that can happen that are involuntary events that you want to make sure the ownership of the LLC is kept to those members. Then there are voluntary events like you just want to leave, you want to retire. How are you going to get out the value of your LLC? And I really recommend if you have an LLC with more than one member that you have provisions regarding it, often referred to as a members agreement or a buy-sell agreement that basically says upon your death, your heirs must sell the shares back to me, and this is how we determine the value. That's another tough issue because small businesses don't have a good stock market to determine the value. So you have to have a way for determining value. Disability is another issue. You're in business with your good buddy and he gets hit by a bus, so he's got a broken leg, maybe out for 6 weeks, you'll probably carry him. But if he's in a coma for 6 months, for 6 years, or you can still give him 50% of the company when he's not contributing, at some point in time you need to define disability as being unable to fulfill your responsibilities to the business, and the guardian or that person, whoever has an obligation to sell those membership interests back to the business. It is something that you see litigated a lot, so I really recommend to all my clients to have a type agreement like this if you've got more than one owner of a business. I'll tell you one other story that was sort of important to me. I had 2 clients come to my SCORE office and they had working for an AV company and thought they could do a better job, so they were going to go out to business for themselves, wanted to be partners, 50-50. One of them was 40 and the other one was 60. Well, we got to talking, and sure enough, the 40-year-old wanted to create an empire. He was looking to reinvest all the capital and really build his company.
And let's say you're a single member, and you passed away, does that go to your wife? Or do you put that in your will, or do you put that
Where
in the
it
member?
goes upon your death is determined by your will.
Okay.
I will say Texas is a community property state, so if you are married and you're the owner of the 100% membership interest of your LLC, your wife is a joint owner with that.
Okay.
Yeah, she doesn't sign documents because you're the named party, but she does have a 50-50 right to. And I should say, if you looked at those partnership returns I was talking about, a married couple that files married filing jointly is not considered a partnership. They're just one taxpayer entity. And so you wouldn't file a partnership return, it would just go straight to your individual 1040 tax return. Yes, ma'am?
So earlier you mentioned that a sole proprietorship, when the person dies, it usually just dissolves.
absolutely can be left in a will, and you certainly can have your children who have learned the business with you. I'm talking more from a collegiality standpoint. Too often there aren't others around to pick it up. Okay, let's go on to the new form of series LLC. New, it's almost 9 years old now. But the whole idea is the purpose of an LLC is to separate out liability within that LLC. So say you have a rental house and you have insurance on it, of course, but you want to make sure that if anyone sues you because they have property damage or personal injury at that rental house, the liability is contained to the assets of the LLC. That if someone injured in your home can sue the LLC, get the full insurance benefits and any value of the property owned by that LLC, but can't get through to you personally. So you're doing so well at this rental house business that you get a second LLC, second property, put it into the same LLC, so the person injured at property A can sue and get the value of property A and the value of property B. And that would go on if you had more properties, operating businesses, assets, whatever, in that LLC. So the practice has been for people owning multiple rental houses was to set up a separate LLC for each one to separate out that liability. That's a $300 filing fee every time you set up a new one and a lot more paperwork. So in 2009, the Texas legislature approved a series LLC. You file it once, you identify this LLC as a series LLC, which is some magic language that I know and will be happy to share. And it basically states that you can set up Series A as like a separate entity that owns the property on Able Street, and Series B owns the property on Baker Street, C owns the property on Charlie Street, and so long as you maintain the financial records, the accounting records, bank accounts, contracts separate among each of the series, there is no consolidation of liability. That is, anyone damaged in the house on Able Street that sues you could only get the value of the house on Able Street. And setting up each of these series is not something you do through the Secretary of State. There's no additional filing fee. There's no additional cost of being a series LLC. You just set it up in the books and records of the company. It generally does have a separate LLC. They're consolidated for purposes of the tax filing. You can say your father-in-law wants to go in with you to purchase a house on Baker Street, but not the house on Charlie Street. You can have different owners for each of the series. Now, here's my caveat. I know if you set up a separate LLC for each property, you could separate out that liability. You'd have to really be a bad slumlord to have the corporate veil of each LLC pierced through to consolidate all of them for liability purposes. But because the series LLC has only been around about 8 years, we don't have a lot of lawsuits based on it, so I can't tell you for sure what level of separation you need among each of these series to be successful in separating out your liability. I can give you a lot of recommendations. Clearly you need a separate bank account, you need a separate accounting system, although I'm told QuickBooks has a provision for that for different series. And from a business standpoint, you'd want to know which house was making you money, which one you're not charging the right rent on or whatever. You should have a management contract. If you're the one managing all these properties, you allocate 20% of your time to the Able Street property and 40% of your time to the Baker Street property. Have that in a written contract. If a plumber comes out and does work on all 3 properties, you separate out that cost among the 3 properties. The whole idea is keep them separate, treat them as if they are 3 separate LLCs, but you only have to file once, one $300 filing fee, and then keep it up that way. Yes, ma'am?
So you made it sound like if you have one business with multiple pieces, what if you have different businesses? Would it still apply?
Yes, I should have made that clear. Absolutely, you can do different businesses. One of the best examples I had was when I had 7 yoga instructors come to me and they wanted to buy a yoga studio and set it up. And just one of them wanted to have a room there in the yoga studio for his massage parlor. He was a masseuse. And two of them wanted to be in charge of the juice bar. So we had a Series LLC, 7 owners of the yoga studio, 1 owner of the massage room, the 2 owners of the juice bar. But you could have easily had an ice cream stand, whatever, anything you want. Yes? My last point here is that you do need these special words, magic language, in the certificate of formation to create a series. All you do when you add it is give you the authority to create series. So consider if you're just setting up an LLC and you think, maybe down the road I'll want to branch into other areas that I want to maintain separate liability in, put the language in there. You don't have to use it immediately, but you can put the language in there, and when you're ready, set up different series within that LLC. Company agreement requirements. The company agreement is the operating agreement I was telling you about before. And there are requirements to put in the operating agreement who the owners are and how each series is different. So keep the records separate to make sure you maintain separate liability.
Can you retroactively change your existing LLC, or do you dissolve that and re-register with the special language?
I would want you to amend it. It's just a matter of filing this magic language. There's a $150 filing fee to amend versus shutting down. I think dissolving is a $50 filing fee, and then you have to set up a new one for a $300 filing fee, so don't do that. Yes. Okay, anything on LLCs or series LLCs before we go to corporations? Okay. So a corporation has been the traditional form to limit liability for ages and ages. Still probably easier to raise capital because most venture capitalists are familiar with the notion of corporations having different classes and series of stock. Venture capitalists, a lot of investors that you have will want to put money in and get the first dollars out, right? So that is a form of preferred stock that they like to see. That can be done within an LLC, but it's much more common to see within a corporation. It's a little easier to transfer ownership because you sell shares. Within a LLC, you have just 100% the pie, and it's not as easy to transfer membership interest as it is in a corporation. Limited liability is the same for shareholders in a corporation, and a corporation will continue to exist until it is intentionally dissolved. You do have to file a certificate of dissolution with the Secretary of State in order to dissolve a corporation. So let's look at disadvantages. Filing is on a Form 201 with the Secretary of State. It's a little different because a corporation has a capitalization, and you can set up shares, classes of shares, series of shares. A corporation has directors, whereas an LLC has managers. Somewhat a matter of semantics, but there are a few differences in the power and authority. The requirements to keep current with the comptroller are the same as I described in an LLC. Every February 15, you'll get that form from the comptroller asking about your subjection to the Texas franchise tax and the PIR as well. You need to file it. It does have more extensive legal requirements than an LLC. Those are principally the fact that in Texas, a corporation must have an annual meeting of shareholders and an annual meeting of directors. Now, if you are the sole shareholder and the sole director, that's just one piece of paper each year. That's not tough to do. It's not required in an LLC. But I think if you have multiple owners of an LLC, keeping those kinds of records is always a good idea. Not required, but a good idea. Here's a primary problem with corporations is that the default position, a conventional corporation, is taxed at the corporate level. And then when the profits are distributed down to the shareholders, that income is taxed to the shareholders. We have double taxation on the same dollars. So no one wants double taxation. That's why the S corporation was set up. And we'll go into that in a minute. Again, from a corporate record-keeping standpoint, a corporation should have bylaws that basically says when the meetings are held, what kind of notice is required, that sort of thing. Stock certificates are required by a lot of certifying entities to show who owns the shares of stock. I've described to you before the notion of a written agreement restricting stock transfers if you have more than one owner, just as important in a corporation as it is in an LLC or a partnership. And a corporation is, of course, subject to the Texas franchise tax. So let's see what happened many, many years ago when people complained that we have small businesses owning this corporation and we shouldn't be subject to double taxation. S corporation is based on the subchapter of the Internal Revenue Code, subchapter S, that defines how you can qualify to be an S corporation and therefore not be subject to double taxation. Because the advantage of an S corporation is that you're taxed only once at the shareholder level. I described the LLC as a pass-through entity. Well, that's what a subchapter S is, pass-through entity. Otherwise, it looks just like a C corporation. And I want to make it very clear, a corporation is set up through the Secretary of State of each state. What we're talking about here is the taxation, which is with the Internal Revenue Code, federal income tax. So, in order to qualify as an S corporation, you can't have more than 100 shareholders, and each of those shareholders should be individuals. Estates, fine if the individual dies, and certain trusts qualify, but what I'm saying here is that a corporation can't be a shareholder of an S corporation. And that's not discrimination, as is the next one. It's a matter of the IRS tracing the income. Shareholders may not be non-resident aliens. They have to be U.S. citizens or green card holders, and that is all the shareholders. Once again, so the IRS can trace the income to their personal tax returns. An election must be timely filed with the IRS. The requirement is that you file this election, Form 2553, within 75 days of your corporation being organized. Sometimes they look at when the EIN was obtained, sometimes it's when you actually have operations, but there's an entire section on the form when you elect to be taxed as an S corporation that says, if you didn't make it within 75 days, tell us why. And you just write, I screwed up, or I got bad advice or something, and they'll let you do it. But the text on file is you must file within 75 days. And finally, a S corporation can't have different classes of stock with different liquidations or distribution rights. This is in case you have that investor or a venture capitalist who says, yes, I'm going to give you my $100,000, but I want the first $100,000 in profits to come back to me before you get it. And it's common. Venture capitalists are in for a quick return on capital and then they're out. But that sort of preferred distribution will disqualify the company from becoming an S corporation. Same thing is if the investor says, if you go under the first dollars you make on liquidating your assets come to me, that's a preference on liquidation, and that type of preference will disqualify you from being an S corporation. Okay, a final kind of corporation, also relatively new, is a public benefit corporation. I'm sure you guys are familiar with corporations who advertise the fact, Tom Shoes is one, buy a pair and we'll give away a pair. It's that sort of thing. We are combining your desire to make money with the bleeding hearts of the world who really want to give away money. So the notion is if you put in your certificate of formation to set up in Texas a B corporation, a public benefit corporation, you can state that it is for the purpose of this charity. It doesn't matter from a tax standpoint, it doesn't change it any. It just allows you, when you make money, to give to that charity, and so your shareholders don't complain, wait a minute, I thought all this money was supposed to come to me. Generally, if you're going to be investing in a company in the stock market, you don't want to see them giving away all their money. You are expecting a return, right? But we are in the era of people's concern about social issues, and a lot of millennials particularly want to see investments in companies that put their money toward the social good. And the information I've read about this is that millennials are more drawn to companies, to be employees of companies who give their money away. They're more interested in helping others in this particular charitable purpose of a corporation than they are in seeing the return to them. So something to consider. I would say if you are the sole owner of the company, you can do that anyway. There's a limit on the tax deductibility of how much money you can give away as a charitable donation, but if it's just up to you, give away as much as you want to and deduct just what you can. But if you have multiple shareholders and you want to make sure your shareholders are ones who understand your interest in devoting time, efforts, profits to this charity, consider a B corporation. And this was passed 2 years ago, so we don't have a lot of history of them either. Okay, one other point I will make is that if you have a profession and you're setting up a professional organization, there are certain entities that you are allowed to set up. When I speak of professions, I've got a good list here: accountants, acupuncturists, athletic trainers, attorneys. I truly just barely got through the A's because this goes on and on. And what I can refer you to is this link here at the Texas Secretary of State's website. They have this wonderful chart that shows for each profession what types of entities you can be. Doctors, for example, can only be professional associations. Dentists can be PCs or PLLCs, P standing for professional. They have entry there for equine dentistry, which, in case you wanted to know, can also be a LLC in addition to PLLC. You want to make sure you set up the right entity if your business is going to be pursuing this profession. Okay, I've talked a lot about the benefit of these various organizational types in order to limit your liability. I think it's really worthwhile to focus in on what kind of limitation of liability we're talking about here. What can be accomplished by setting up an LLC rather than just being a sole proprietor? Because there are two types of risk. One is contract and one is tort. I'll get to explain tort in a minute. Contract is like your bank loan. Believe me, if you go to a bank and say, my newly organized LLC wants to borrow money, they will say, fine, we will put the loan in the name of your newly organized LLC, but since it has no assets, you are guaranteeing the loan. Same thing if you go to your landlord. Landlord is not going to accept the signature of just your corporation or LLC to the lease. You're going to be personally guaranteeing it. Happens with some vendor-supplier contracts and equipment purchases, less so because those are almost always secured by the equipment itself. So my point is to you, if you're really trying to limit your personal liability on these contracts, you're not doing it by organizing an LLC or a corporation. As a practical matter, you'll be required to be a personal guarantor of them. So how can you limit liability? These are the types of liability that can be limited. It is a tort, which is basically an infringement of the rights of others. The guy slipping on the banana peel is a quintessential example of it. Someone comes into your place of business, slips on ice, whatever, and your insurance would, of course, cover whatever kind of liability there is, but say he broke his back and he's $1 million client and your insurance policy is $100,000, that $900,000 excess is on you. Unintentional failure to act in a reasonably prudent manner, thereby causing harm to others, is an unintentional one, and we can all be guilty of unintentionally harming others just through negligence. So say that guy who slipped on the banana peel gets a judgment against your company for $1 million, and you say, here's my insurance, $100,000, that's really all I've got. So he gets a judgment against your company for $900,000. He can wipe out all the assets of the company. He can attempt to cut through that corporate veil of your LLC in many ways, including by saying, no, you have a very dangerous place of business and you should have had $1 million worth of insurance here, and get through to your personal assets. If it gets a judgment, the judgment, even if you can't collect it against you, is good for 10 years and can be renewed every 10 years. So this is something that even if you ever sell your house, here's a judgment that all the proceeds of the house sale would have to go to satisfy. Believe me, there are plenty of complications to this. So the types of tort liability that you can't limit is intentional. the intentional torts like assault and battery, libel, slander, trespass, fraud, and misrepresentation. Say you own a restaurant and that guy who just walked in was the one who ran off with your now ex-wife and you decide to punch him out. Well, he can sue for damages. He's not suing the restaurant, the corporation, or LLC. They didn't punch him out. You did personally. That is an intentional assault. Slander, trespass, think of those in terms of social media if there's any kind of fraud and misrepresentation too. You can't protect those events by simply setting up an LLC. If you're a professional attorney, accountant, physician, for example, you have liability for your professional services. You can't go into a doctor's office and he commits malpractice and he says, well, you get the value of what my LLC owns. There's a gurney, here's some furniture in the receiving room. No, he is personally liable. It's a different kind of insurance. And gross negligence can result in personal liability too. So look at your business type and figure out what kind of liability is likely to arise in your business and the extent to which you should be protecting it with insurance or with the formation of an LLC or corporation. Question?
Yeah. How do you prove gross negligence?
Well, to a judge and jury, and I will say sympathetic plaintiffs make a good case if you've got someone who is young and egregiously hurt because you just had ice on the floor because it was an ice storm that day. You know, you can bring up your defenses, but
So you have
can
to
be
grade.
yeah, that. And most insurance policies don't cover that. Do you have a question up here?
That was agreeing to the insurance policy.
Oh, yeah. Well, you'll see insurance is an important issue here too. Okay, let's go on to, I think we've finished that. So you set up your entity. It's not enough simply to file and pay $300 and respond to the comptroller every May 15. You have to maintain your entity as a business entity. Otherwise, someone could say, this is not really a separate corporation or LLC. This is the alter ego of you. We're going to pierce through the corporate veil and get to your personal assets. So, the DBA is the assumed name certificate, which I mentioned for our sole proprietorship you need to file. Only if you are using a different name than the name you incorporated under do you need to file that for a LLC or corporation. You need to, if you have a corporation, either adopt bylaws or if you have a LLC, set up an operating agreement. Keep your records of meetings. It's always good to have. This is just paper, but someone accused you of having a entity that is just a shell because